Okay, good morning, everybody. Let me start with our professional practice main paper 2022. Everybody can see the screen, right? Okay, so let us go to question number 1. Okay, so I think everybody have read the questions, right? So basically, this is an essay questions to ask you to cite all the relevant rules under LPPER, which is Legal Profession Practice and Etiquette Rule, and also Solicitor Accounts Rule. So before that, can I just briefly tell about what is professional practice? So basically, professional practice is a subject to talk about what lawyer should or shouldn't do. It's more like a moral, a lawyer moral. We can do in what situation we can accept a case, in what situation we cannot accept the case to conduct the case, and also what you shouldn't do. Okay. And I believe there's a few rules you guys must take note. If I may, I just briefly highlight a few rules that we will use quite often, which is number 1, legal profession, practice and etiquette rule. That one definitely is more like talk about in what situation you can take the case, in what situation you shouldn't do something, you should do something. And then the next one will be solicitor's accounts rule. That one talk about how you control your account. Okay, I don't know whether you guys know or not. If you open a law firm, we will have 2 accounts. One we call client's account, another one we call office account. All the money should go to client's account first. It's because Bar Council try to prevent a lawyer who accidentally use the client's money. For example, let's say client pay the money, not all money belongs to you. Maybe only certain portion is legal fee. But other portion like stamp duty, real property gain tax, that one you just collect on behalf of your client, then you pay on behalf of your client. But because Bar Council don't want you accidentally use that money, so they will create 2 accounts. So you put all the money to your client's account first. You cannot use your client account for your own purpose. I believe you will see all the past questions talk about like Ali is a lawyer, Ali got the client money, and then Ali accidentally used the money for medical purpose. So can the client right now sue Ali for misuse of the client money? If Ali put the money back, is it okay if the complainer withdraw the complaint? Can Bar Council continue the process? Those kind of questions. That one is under solicitor accounts rule. Okay. Then the next one is solicitor remuneration order. I believe many of you don't know how to calculate legal fee. So basically for solicitor accounts rules, orders, that one is to cover where, let's say you are doing a transfer file. So they ask you how to calculate the legal fee. So the legal fee commencing, I would say, for transfer, for charge, is actually the legal fee is governed by solicitor remuneration order, which means for commencing, there is a skill fee. You need to follow how they calculate the legal fee. However, on the other hand, if you are doing litigation, pursuant to Rule 11 Legal Profession Practice and Etiquette Rule, you have no skill fee to calculate the legal fee. However, on the other hand, if you refer to Rule 11, the calculation actually it depends on a few factors. If I may, I refer to Rule 11 LPPER. Okay, some people waiting. Okay, so Rule 11 basically says that in determining the amount of fee for litigation or contentious matter involving representation of a client in court, it is proper to take into consideration A, the time, labor, and skill required. B, the novelty and difficulty of the question involved. C, whether acceptance of the particular employment will preclude his appearance for others of which he has reasonable expectation. So which means you can see for litigation is more like depends on depending the time, depending how complexity is that, there's no skill fee. So whenever the passing question asks you, so if I conducting a litigation matter, is that a skill fee for me to calculate? So the answer is no. However, if there's convincing, then there is a table for you to calculate. I'm not sure whether you guys know how to calculate or not, but if I may, maybe I just quickly go through with you. We go to the past year question we have. Just a quick one. I think it's this one. Okay, so basically under this main paper 2020, question number 1. So in this case, they have a property value, they want to do the transaction involved is 1 million. Okay, so for 1 million, the facts also mentioned, they charge the professional fee is 3.5, equivalent to a purchase price, which is 3.5 times 1 million. So actually the calculation is wrong. Pursuant to solicitor remuneration order, the calculation should be like this. First 500, 1%. It's divided, by the way, it's like first 500 and then the next 500. It's not sure we use the 1 million to times 0.8. Because I know a lot of people, they will sure away use that figure. But actually, it's like first, which means you need to use the first 500 times 1% first, and then the next 500 times 0.8%. So this should be the calculation at this table. But never mind, if whoever who don't understand, then we go into details later. So let us continue with what are those rules we are often used in the exam. So after solicitor remuneration order, another one I think is quite important, which is legal profession disciplinary proceeding. However, please take note, the latest legal profession disciplinary proceeding rules is 2017. It's not 1994. Because I know some of the books, they are still using the old law. Actually, right now we have the new law already, which is legal profession disciplinary proceeding rules 2017.
Warning in progress.
Let me show you. So this should be okay. I think let me mute. Okay, so this should be the latest one, 2017. So in case anybody who are still using or referring to 1994, please take note, the latest one should be 2017. And then another important rules you should take note, which is legal profession publicity rules. Okay, again, let me explain. Generally, we are allowed to post or share some promote your law firm in social media. However, you must comply with legal profession publicity rules. So if you refer to legal profession publicity rules, if I'm not mistaken, it's rule 4 or rule 5. Let me flick to it. Yeah, rule 3, sorry. So rule 3 says, this rule applies to every advocate and solicitor, whether he is practicing as a sole proprietor or as a partner, employee, or consultant of the firm, which means all lawyers must follow this rule. And then rule 4, advocate and solicitor not to publicize except in accordance with this rule, which means you can publicize, you can post something, you can promote. However, you must comply with rule 4. And one thing you need to understand, you can only post or share or promote those approved information. And what is approved information? You can refer to rule 2. So according to rule 2, in approved information means the name, the address, the telecommunication number, business hour, the year, the merger, historical data, etc. Which means if the question asks you, hey, can I say something? Let's say I say I'm a super good lawyer, never lose a case before. Then you need to check whether they can share something which is not covered in the approved information. If the approved information says you cannot post this thing, then you cannot. You can only share or post whatever under approved information. Understand? So I think most of the question, passing question, they will ask you about, can I say I'm a super good lawyer? can I say I'm the like a justice defender, something like that? I don't think so, because approved information doesn't include all of this. So for those rules I mentioned, which are those quite a basic rules, you must take note and you must master it before you attend this professional practice. So let us go back to this question. So for these questions, they basically talk about to say, in one case, a judge specifically says that, for me, I will take note is that they say, unless high standard of conduct are maintained by those who pursue a profession requiring great skill, okay, trust and confidence of the valid committee that is to preserve its laws, trust the function itself of the professional is frustrated. So basically they say we need a very high standard to maintain our profession. We cannot simply let people destroy our trust. People trusted lawyer, okay? Then another point I would like to take note is that, yeah, this one. Practice of law is not business. It is a profession in which duty to public service, not money, is the prime consideration. So basically they say, become a lawyer, you don't think about money first, think about justice. So this is what they say lah. So, but all this actually the body doesn't matter lah, because at here, they are asking you, in what way do the rules of the professional practice and etiquette made by the Bar Council pursuant to Section 77? So Section 77 gives the power for Bar Council to make those rules to control and govern lawyer. Ensure each of the above duty are fulfilled, which means whatever above the details, like say that they say cannot practice for money, our trust and confidence must be maintained, etc. How to reflect in our rules, especially the expressly mentioned LPPER and also solicitor accounts rule. So, like I say, you must very familiar with those rules before you answer this kind of question. And again, like I always say, I don't encourage students to essay questions, because you need to have a better and beyond that understanding in order to answer. Someone is 20 marks. But since this is a tuition, then we will just try using our knowledge to attend. So basically in this question, when they say you need to find those keywords, so I think this is quite easy to say you must gain the confidence, you must gain the trust, you cannot spoil our standard. This is those very common rules we always use, which is Rule 16 and 31 LPPER. So please have your LPPER, then you flick to your Rule 16. So Rule 16 is advocate and solicitor to uphold interest of justice, interest of client, justice, and dignity of the profession. I think this one is very common. You can use all the situation as long as it's talk about our reputation, our face, how to keep our face, etc. Then you must use this Rule 16. And against here, they mentioned our special skill, our profession, and profession is frustrated. So you must use this to answer. Park also already say, juggle our face. Rule 16 says so. So another one is, Rule 16 always come together with Rule 31, which is advocate and solicitor to uphold the dignity of profession. So both of these is talk about how to juggle our face, how to make sure our standard, our dignity is maintained. So next time, I don't know whether you guys know or not, the Mr. Gong, a lawyer who are from Malacca, claimed himself as a Huang Li Hong. I don't know if you guys know or not, one of the famous singer in Taiwanese. He is lawyer. But actually, I quite wonder how come Bar Council never take any action against him, although he liked to wear woman clothes and dress.
Orange here.
Sorry? Okay. Yeah. So that guy actually is a lawyer who practicing in Malacca. If can later I share in the group who is that. But so far Bar Council, I don't know, maybe I don't know. Bar Council never take any action. But by right, pursuant to Rule 16 and Rule 31, to uphold the dignity of the Bar Council, that guy should be disciplinary action should be taken against him. Okay. Then another rules we can take note is here. They say you cannot just take the case for money. We are more like towards what we call Okay, they say money is not important lah. Money should be the secondary lah. So where says in what situation we should or shouldn't take the case, my opinions will be rule 3, rule 4, rule 5. Why? Because if you refer to rule 3, they say advocate and solicitor not to accept brief if embarrassed. So which means you shouldn't think about money first. You should think about whether you can handle this case or not before you take out the case. Rule 3. And rule 4, no advocate and solicitor to accept brief if professional conduct likely to be impounded. Which means if you cannot handle it partially or injustice, then you shouldn't take out the case as well. And rule 5, no advocate and solicitor to accept brief if difficult to maintain professional independence. So all three, rule 3, rule 4, rule 5 is like, I think you can use interchangeably lah, but they are quite similar. So, but basically you can reflect all these rule 3, rule 4, rule 5 to say that yeah, Bar Council already say you shouldn't think about money first. Not to say every time for a case you must take. You must think whether you can handle it or not. If you cannot handle, don't take it. You can never tell Bar Council to say, I take this case because of money, good profit, so I take this. No. Must for justice first. You can take it first. And also another one is rule 6. Advocate and solicitor not to accept brief is unable to appear. Which means, let's say a lawyer take a case already. He cannot say, okay, this month I'm not in Malaysia, I'm traveling to London. So please don't contact me until I come back from London. So cannot. Pursuant to rule 6, you must make sure you are ready and you can attend the matter before you accept. So all this actually in the way you can argue lah. If you are not ready, don't take the case. If you take the case just for money, then too bad. You against these rules already. So this is all the rules I would think you can answer for this question. But again, understand, you understand is one thing. Like I say, asset question, you need beyond that. You also need to structure the answer lah. So for LPPER, my suggestion is that you can use rule 3, rule 4, rule 5, rule 6 to answer in what situation we can or cannot take the case. We can accept the case. And on the other hand, rule 16 and rule 31 is to answer this part, talk about our profession standard and how to maintain it, our dignity lah. Okay. Then how about this solicitor accounts rule? Like I said just now, this is talk about account only. So how these two paragraphs we relates to our solicitor accounts rule. So if I may, we refer to solicitor accounts rule. But actually solicitor accounts rule is not very long, just a few sections only. If we go to solicitor accounts rule, okay, since we talk about here might as well I just explain to you what is this solicitor accounts rule. So you just need to take note of, I think, less than 5 rules lah. So number 1 will be rule 3, duty to pay money into client's account. So basically here, whenever people ask you, hey, where says that I must pay the money to client's account, then you tell them rule 3 says so. All money should go to client's account. Because like I mentioned just now, Bar Council don't want those arguments come out to say, hey, I accidentally used the money hey, I never calculate I thought that one is my money No, that money is for client, so you must pay into client's account. So another one rules you must take note will be rule 7, which is in what situation you can withdraw money for client's account. So those are the situations, so you guys can take a note But if you're lazy, then you can just remember we can only use that money on behalf of the client. Like I said just now, for stamp duty, for real property gain tax. So for those people who had done the intern before, I think you will know what is stamp duty, what is real property gain tax. Basically, it's just a tax. So you are paying on behalf of your client. So rule 3 and rule 7 money paid into client account, in what situation using the money on behalf of the client. Another one appear in a passive question, which is rule 7 capital A. So they ask you, who can be the signatory of the client's account check? Let's say today I want to issue check. Is it like whoever also can issue this check or only lawyer? So pursuant to rule 7 capital A, the person who can issue check will be the client's account. Please take note. Number 1, advocate and solicitor practicing as a sole proprietor. Sole proprietor is like me Only me in the firm is a boss. I don't have any other staff. But if you have staff also, it's fine lah. But I don't think if with staff we call sole proprietor lah. Sole proprietor means like one man show lah. You do everything yourself. Okay. Number two, partners of a firm or solicitor. So let's say one day Dr. Chi and Mr. Gan open their firm, they become partner. So this apply to them. Either of one of them, they can sign the check lah. Okay. And C, a legal assistant, especially authorized by a proprietor. So many of you may ask me, so legal assistant means lawyer or not? I don't see a definition here, but my personal opinion is legal assistant is a lawyer. And some students also will ask me, what is the difference between legal associate and legal assistant? For me, they are the same lah. Unless somebody don't agree lah. Okay. So if I may quickly just show you the past questions, just give me a moment. There's just one time they asked about this to say who can be the signatory to sign the check. Let me see. Yeah, I think it's this supplemental 2020. Let me show you. Question 2B. So this one, I just quickly go through with you guys. Any and advocate solicitor practicing as a sole proprietor under the name of MP, ANI, and Co. So you see, when they say it's a sole proprietor, then pursuant to Rule 7A by right should be the sole proprietor, the lawyer lah. Okay, it's also serving as a member of parliament. So again, those smart students, they will know lah. Member of parliament. So question is, can a member of parliament also become an advocate and solicitor? Interesting thing, I know many people may say cannot, and like I said, we are lawyer, we cannot only say cannot but without telling the authority, So which rule says a member of parliament cannot become a lawyer? Pursuant to my limited information and knowledge, is Rule 7, Legal Profession, Practice and Etiquette Rule. So if I may go to Rule 7, today we will keep on fitting a lot of rules. So please familiar and have LPP, LPA, and all those rules with you. So if you go to Rule 7 LPPER, the title is no advocate and solicitor to accept remuneration remuneration in capacity as member of parliament. So you see, I don't know why they say cannot, but if you just literally read the Rule 7, the Rule 7 never say cannot, they just say you cannot accept remuneration, which means you cannot take salary only, So I'm not sure lah. Of course, I stand to be corrected lah. For me, I'm reading Rule 7. It doesn't say you cannot become a lawyer and also a member of parliament. They just say you cannot accept the salary. I don't know why actually. Maybe to try to protect those YP because they can take 2 jobs I guess so. But never mind. Please take note. This is Rule 7 LPPER. Any delegated all office work to the firm account manager, including the duty to deposit check into account maintained by the firm. Again, this is another issue. Since we are doing tuitions, right? I might as well we just do all kind of questions. Okay, bear with me. So you see, the question is, can a non-lawyer manage a firm or not? Actually, cannot also. There is another rule, if I'm not mistaken, is rule. Wait, I better refer to my notes. I'm more familiar to my own notes. Yeah, my rules is Rule 59. Advocate and solicitor shall not maintain branch office unless in the name of his firm and managed by a qualified advocate and solicitor. Again, I know that student will tell me, hey, Reno, no, this rule say cannot maintain branch office, So it means the main office can control by what we call non-lawyer, No, actually, I don't think it doesn't make sense, because actually you can check whether a person is a lawyer or not by going access to the Bar Council website. So if you say this rule only applies to branch, so which means I just need to open a lot of branch controlled by lawyer. However, my main office is not controlled by a lawyer. I feel it doesn't make sense. But like I said, there's no right or wrong answer unless the law clearly says so. Unless you can find me a case law. For me, I will definitely use Rule 59 to say this. You shouldn't control by a account manager. Okay. Then this one. all check must be deposited in the office account. See, mati already long. Just now we say all money, rule 3 of the solicitor account rules must go to client's account. Remember, it's client's account. Client is more important. But this money, they go to office account. Okay? So it's wrong already against rule 3 of the solicitor accounts rule. Next one, an adjustment will be made at a later date. This one I think is fine. They adjust later. But actually, the first place, they also wrong already. They shouldn't go to office account. Okay. Arnie had also managed to convince the bank manager at the ABC Bank Berhad to allow account clerk to be an alternate signatory to the firm account, including client's account. So you see, this is against Rule 7, capital A of the solicitor accounts rule. So this is the question. And of course, those like they ask you about client's money and trust money, you can actually find in the Rule 2 of the solicitor accounts rule. They have already defined what is client's money, what is trust money, etc. So whoever attended the sit for the exam in 2020, then unfortunately for you, because you cannot bring in the rules, but you have to know. Actually, honestly, it's quite unfair, because never asked before. Like I said, we usually only ask rule 3, rule 7, but then this year they asked about 7A, they also asked about rule 2, what is the definition? So for me, I think it's not easy, but it's okay. We just learn from the past year questions. So you can only prepare based on whatever happened past, then hope with the hope that they will ask the similar questions. Okay, I think I see some question. So we should write cannot for the part of member of parliament. So we should write cannot for the part of member of parliament. What do you mean? What do you mean we should write cannot for the part of parliament? It means like cannot practicing as a lawyer and also become a member of parliament. Okay, like I say, Rule 7 never expressly say you cannot become lawyer and also member of parliament. They just say you cannot take the salary. You just cannot take salary. Which means if you don't take salary, then you can become member of parliament and also take salary. See, somebody mentioned the name already. Yeah, actually there's a lot of people also, you know they are YP and also they are lawyer one. So maybe behind belakang they never take salary, we don't know. I don't have any friend is member of parliament. So whoever has a friend is a member of parliament, please let us know the answer. Yeah. Okay. So let us go back to our questions. So let me repeat for this kind of question, because they talk about money is not important and also how to maintain our dignity. My suggestion is that for LPPER, I will mention Rule 16, Rule 31 for maintain the dignity and uphold the standard. For the money part, I will mention Rule 3, Rule 4, Rule 5, Rule 6 to say money, we shouldn't consider money first. We should consider whether we can take out the case or not, handle the case independent, and also it doesn't affect our independent. Okay. And then for SAR, I will talk about Rule 3 and Rule 7, which means those money should go to client's account. You shouldn't misuse the client money. Okay. Okay, I saw a question they asked, sir, can be like Grab driver on weekend? Very good questions. Dun, dun, dun. Actually, I think Park Council also know our salary is quite low. So they do lenient on certain people who can do part-time. So pursuant to Chapter 12, 0.1 Park Council ruling, advocate and solicitor who is a sole proprietor like Reno, I'm a sole proprietor, or a partner of a firm may engage on a part-time basis in the business or trade. So unfortunately, they only allow bosses to do part-time. So those people who work for people cannot do part-time. But of course, I stand to be corrected. Whoever who know any latest law, please let me know. My knowledge is this one. Only sole proprietor. Okay. Then shall we continue? This one. Quite a long question. Let me take a glance. Never mind. We go through one by one. Okay. Hey, an advocate and solicitor and a partner in Kada, Dista, and Co. were approached by Andy. Andy is being sued by one of the creditor, Franco, who is distant cousin of Kadan's wife. Kadans know that Franco, a hardware operator dabbled in counterfeit products. A few years ago, Kadan's firm had represented Franco in the suit by another customer and had learned about Franco trade secrets and other sensitive information. Given that Kadan was the head of the dispute resolution, him in the firm, he was indirectly acquitted by the facts and documents. So basically, they are saying K represent A because A was sued by F. So this F previously is K client. So K in a way have some information from the previous transactions. So right now, I think using common sense also we know lah. Like I say, professional practice is more about moral, whether a lawyer got moral or not. Although a lot of people they don't have lah. Okay. So how come we? Okay, never mind. So I think common sense, if you have those info, you shouldn't release or disclose confidentiality lah. I think this is quite understandable, right? But again, like I say, we are lawyer ma, we cannot just say ma, we must use the law ma. So for me, confidential is this. Rule 35, LPPER. Advocate and solicitor shall refrain from any action whereby he personal benefit or gain he abuse or take advantage of the confidence reposed in him by client. The obligation of confidentiality remain even after the end of employment. So I don't know whether some smart student will tell me or not. Hey, Reno, no ma, this is previous deal ma. So since already passed, already done the job, so there's no more confidentiality. The answer is no. And also we know about 126 Evidence Act. The duty actually is continued even after you complete the job. It's actually until you die lah. Okay. So remember, it's Rule 35 for this confidentiality. You shouldn't disclose your client info. Okay. Again, since we talk about Rule 3, Rule 4, Rule 5, Rule 6 just now, right? In what situation you shouldn't take the case, right? So since he has some information of his previous client, it may affect what? Professional independent. I suggest maybe we can use Rule 5 as well to say, hey, in this situation, actually you shouldn't take because you have some confidential information. So my suggestion for this is Rule 35 and Rule 5. Rule 35. Yes, Rule 35. Okay, let us continue. And the main end is to buy himself some time to enable him to dispose his property so that any judgment if obtained will be incapable of being executed. K mission, if he choose to accept, is to delay the process and discharge himself at the appropriate time. Again, C, which means they are trying to play the strategy delay so that the defendant can dispose of all the asset and money. So even though this Franco got the judgment already, also cannot execute. I don't know you guys know or not. Actually, when you sue people, actually there are two stages. Number one is to win, to get the judgment, to say you win this case. So the people owe you money. The court certified the defendant owe you money. So this is number one. After that, only you go to another court to enforce your judgment. So which means you win is one thing, but if you win the case already, the person who are not able to repay you the money, in practice we call paper judgment. So basically you just got the paper to say you win, but then you cannot get anything. So here he intention is to delay so that he got sufficient time to sell off all he think. I don't know how he do maybe transfer to his wife This is all everybody do So yeah, they transfer all the property to the wife. So when the judgment obtained, even though want to against this who is that Andy. So even though want to against Andy, Andy don't have any money already because all money and all property goes to his wife already. So and also K mission is to delay. I think like I said, this is quite common sense. You shouldn't do that It's against justice Like those people who watch Hong Kong drama, we fight for justice You cannot do something like this right? So those section relevant, I would say is this number one, they say they want to delay I think delay is this one. Rule 12. Advocate and solicitor shall not conduct a civil case or defend with the intention to delay. So, this is number one. Then I think Rule 24A also, if you want to use, advocate and solicitor shall make every effort to be ready for trial on the day fixed. So you cannot purposely delay. And also, just now I mentioned Rule 6, Because right now they say pay one to delay and then discharge himself at the appropriate time. So then we should start to say, hey, you shouldn't discharge yourself easily. You should make sure you can take up the case. You are able to attend. You cannot find excuse one. Okay. Then, okay, so I repeat. I would use Rule 6, Rule 12, Rule 24A. And then another one, they say they want to tipu the court. Okay. Tipu the court confirm cannot lah. So another one I will use is this one. The title is here already. No decision on the court. Rule 17, cannot tipu. And then, yeah, I think that's about it. Rule 17. No more already. So let me repeat, which is Rule 9, Rule 10, Rule 16. Sorry. I saw wrongly. So the answer should be Rule 6A, Rule 12, Rule 24A, and Rule 17, which is cannot tipu the court. I think it's good enough already. By the way, you guys don't so greedy, ask for so many law. This is just one of the part, So don't write a lot of things unless you can remember. So here we already got confidentiality and Rule 5. So here for second paragraph, we can answer using Rule 6A, Rule 12, Rule 24A, and Rule 17. Okay? All these are LPPER, by the way. Then, Franco come to learn from his solicitor that NT want to retain Kanda firm. He then approached Kanda and informed him, if Kanda can conduct the case which can result the judgment being entered in Franco's favor, Kanda will be remunerated handsomely with nothing less than 20% of the judgment sum. So here basically they say defendant engage Kanda, plaintiff now also come to engage Kanda to say, hey, if you help me, I can pay you 20% under table. Of course, this one cannot you cannot act for, you cannot take two This is what we call conflict of interest. But if I'm not mistaken, I think I cannot find any law to talk about conflict of interest. I don't have any law. So this one maybe I need to apply exceptions, because like I say, I always say we must have written law, but for this one I really don't have. So we just say conflict of interest. You shouldn't one time you accept defendant appointment and also you take out the 20% for the plaintiff. So yeah, 10 mark I think is good enough already. Okay. Okay, so like I say, if I don't see any question in the chat box, so I assume everybody understand. Okay, so next one, B. Although there was no express retainer, the solicitor-client relationship may be implied from conduct of the party and circumstances of the case. I think someone asked this question in the group before, and I think if I'm not mistaken, I answer also. Okay, retainer in general or layman English means I appoint you. So today I appoint Dr. Chi. So this is retainer. A lawyer, a client appoint lawyer. So they are asking you, if we have no express retainer, which means like I say, I expressly say I appoint Dr. Chi. In what situation, give 3 examples, the court may help there is an implied retainer. So in what situation, although there is no express or written retainer, the court will say there is a solicitor-client relationship. Again, if in the situation where we don't have any case law, then we can only use common sense. I think for ethic advocacy, we can use common sense. But of course, it would be better if you have the what we call rules. But my personal opinion against, I need to put a disclaimer like Dr. Chi do. You cannot take any action against me because this is pro bono. I don't know you guys know or not. Usually, free thing, you cannot sue one. You cannot sue people for free gift. So I personally think number 1 will be, let's say a layman go to a lawyer office and then the lawyer also start doing the work. This is an implied retainer already. Why? Because I go to your office, you help me start to do the work, although we have no express retainer, but then you start to do the work already. So you cannot say you help me to file an action and then you handle the case badly and then you say, actually, I'm not your lawyer, just doing in favor. Cannot. So this situation, I will say there is an implied retainer. Number 2, you start doing the work, although you have never signed an express retainer. This is the number 2, I would say there is an implied retainer. because you already started to do the word what? By conduct itself, it means you accepted the word already. And then number 3, of course, is the client make payment to you lah. So when the client make payment to you already, you cannot say, oh, this is paid for my makan, belanja mi makan. Cannot, because the money must go to client's account. How can the client pay money for makan to your client's account? So I would say, number 1, when you attend the lawyer office, he start to do the word. Number 2, he started by conduct to accept your word. And number 3, you make payment to this lawyer. These 3 will be the situation impliedly to say you retain the lawyer as your lawyer already. So this is general common sense answering the question, yeah. So how going to answer with a better answer? So I do have a case law. Let me share with you. I will share in the group later also. Let me see. Law. Where is law?
Reno.
Yep.
Good morning. Can I ask one question? Like,
Yeah, sure.
implied retainer, does this mean like the client retain the solicitor? Is
Yes.
that a form of solicitor-client relationship? Means like they expressly told you, I gonna like want you to be my lawyer, but I impliedly want you to, I don't know, because I found when I try to attempt this question, I go online and then I found one cases. It's try to like explain like a kind like solicitor relationship, solicitor client. It didn't mention like, maybe I will share you the link. Maybe you could have a look. You also put a cases and then lay down the 3 principles. But I'm not sure whether I could use the 3 principles in this question or not. Later I will share you the link in the chat.
Can, no problem. If I heard you correctly, you are saying what does it mean for express retainer and implied retainer, right? Okay.
Yes.
Okay. So express retainer, like the word suggests, means expressly I say, Dr. Chi, can you become my lawyer? Then Dr. Chi say, okay, then we sign a letter. So this is express. So you think no question can ask. Express. Section 91, 92. When we have written agreement, we trust written agreement first. Okay. Then implied means we don't expressly say so, but then by conduct, it seems like you are my lawyer already. Like I say, go to your office, I pay you money. So let's say my client pay me money, I started to do the work, but we never sign a retainer, express retainer, or we call letter appointment. Cannot be one day, suddenly I say, actually, I don't know you. You pay me money, just so happen I do your work. Cannot, right? So this is implied retainer. Okay? So the case law I have, okay, like I say, because LPQP don't really give a relevant case law, so I find myself also I think this is quite useful because here especially they mention solicitor-client relation may arise either A, express agreement, like I say, expressly we have a letter appointment. B, where there is express assertion by a solicitor to act for the client. Let's say today I say, Dr. Chi, I help you, I defend for you, I say so. Then number 2 will apply, the relationship established. Number 2 may be implied. So like I say, we never expressly say so. However, by conduct, the court say that is implied retainer. You are his lawyer. Okay. So proof of such relation require an objective consideration of all the facts and circumstances in order to come to a reasonable conclusion. So which means we cannot just say yes or no. We must consider the situation before the court come to the conclusion that there is an implied retainer. So number 1, the purported client has sought for advice or assistance for the solicitor. So let's say Dr. Chi will call me, ask me, okay? Number 2, the assistance sought for was within professional competence of solicitor. So let's say if Dr. Chi call me to talk about girl, to say which girl very pretty, then that one is not my profession. Okay? Number 3, the solicitor expressly or impliedly agree to provide such assistance or reasonably should know what the client would reasonably rely on him to provide the assistance. So if let's say Dr. Chi asked me, hey Reno, I have a clinic. And also the employment law recently they changed so he asked me about my professional information or opinion. Then I also say I will help him to draft a new employment contract. So all this because in my capacity also I know he will rely on my draft employment contract. Then that one can be established as a fact that we have an implied retainer. Then number 4, last one. It was reasonable for the client to believe the solicitor was representing him. So of course, like I said, this is all the factor must consider. So let's say Dr. Chi satisfied ABC. He asked me, I'm a lawyer, he want opinion, and also he will rely on my opinion, okay? But then, last one, unreasonable for him to think I'm his lawyer. What leh? My interpretation is Dr. Chi feel like I don't need to pay Reno. I want to ask for free. Maybe I belanja him makan, then he can drop for me already. So maybe in that case, the court might think, hey, how can you expect a lawyer do work for you for free? Something like that. But like I said, the court couldn't give a firm answer to say must make payment, only consider his lawyer. Or must not make payment, also can consider that as a relationship. So I don't think the court will say that, but it's more like the court will consider the situation. Okay, so this is the factor the court will consider. Let me see, here. It may be employed by the conduct in the party in particular case. Indeed, it should be noted that a retainer in relation to a solicitor-client relationship can be at least in 3 forms, namely the payment of certain amount of money to the solicitor to be placed in trust account or professional relationship. This is what I say just now. When you make payment, then cannot the lawyer say, no, I make payment for fun only. Cannot. So quick payment is one of the conduct to say there is a relationship. Then that between a lawyer, solicitor, and client under given facts and circumstances, or an agreement the existence of which depends on the facts or circumstances of each case. Honestly, belakang also I don't quite understand, but I will share this whole case in the group. But basically, if you ask me, I think to prolong your sentence, because it's 10 marks, you need to write the general position, the general law first. The general law is we can have express, we can have implied, we can also have express assertion. Then only you say in implied how the court will come to the conclusion whether there is an implied retainer or not. So these are the factors the court will consider. Okay, so let me share the case to you. But you guys will notice this kind of question, honestly, during exam, you cannot answer one because this is out of your knowledge. Okay. Okay, let us go to next one. Let me see. Is there any question? Okay, thank you for the link. I think I better share this link to the group as well, so that later everybody can read also. Okay, thank you, Chun. So next one. A, an advocate solicitor has been in practice since 1998, all the while in partnership with B. A complaint was lodged by one of A client M that A has failed to disperse to Minggu to M the balance of the sale price of 880,000 in the S&P transaction, where A acted for M, the vendor. So this is one of the situations you guys should take note also. Like I say, those money will go to client account, can be the selling price, which means today Reno and Dr. Chi. Reno want to buy, Dr. Chi want to sell. But then Reno also worry, Reno pay money to Dr. Chi. Dr. Chi never give Reno the land. So we don't charge each other. So we find a third party, Mr. Kang. So Reno give money to Mr. Kang. Dr. Chi give title to Mr. Kang. So Mr. Kang will do these two things. Go register Reno name, pass money to Dr. Chi. So what we call Mr. Kang is we call stakeholder. You guys know stakeholder, right? In civil law, stakeholder interpreter. If whoever don't know, just write in the chat box later. So this stakeholder will technically hold the selling price, right? So this fact also the same. This A hold the selling price, but then fail to release the money to Dr. Chi and this M. Okay, so A claims the money was misappropriated by B, who had control over his check and has been pre-signed by A. Okay, then a disciplinary committee was actually formed to inquiry into a complaint against A by M. So basically, there's a DC lah. I don't know whether you guys familiar with this disciplinary action or not, but please do remember disciplinary committee I short form I call DC and disciplinary board I call short form DB they are not the same basically DB is the boss. The boss asks the DC, which is Mandarin we call Mazai, go and do investigation so DB is the boss DC is not the boss DC is just a panel, it's a group to do investigation only okay. So now whether the complaint must be made within specific time, as he believed 3 years have lapsed on the day of the alleged misconduct. So again, like I always say, when we don't know the law, then we use our general understanding. So I think this misappropriate of money, we can use Rule 6 Limitation Act, tortious action, if you don't know lah. But one more thing I would like to share. If the questions are only worth like 2 marks, 5 marks, usually lah, this kind of answer you should be able to find in the statute one, because this is just a yes or no answer only. It's not unlike like 10 marks or 20 marks. They will require a lot of cases like yes, no, argue, different scholars say anything differently. But for 2 marks, it is quite sure it's a straightforward answer. So this is about legal profession. Disciplinary actions. So of course we need to refer to our legal profession disciplinary proceeding rules 2017. 2017, yep. If I may, I go and download for you guys. Give me a moment. Legal profession. In the meantime, I mean, whoever got question can type first. Let me download the rules because my hand is not that fast. Okay, actually my hand is quite fast. Unfortunately, it's Malay. Sad. See, got English or not? Wait. Got English. Behind got English. So the question is asking about the timeline, right? To say, 3 years or is it lapsed already? So then we just look at the title. See, I sure we can see already. Rule 6, limitation period. So we should go to Rule 6. Again, I want to emphasize whoever who come late just now, we are right now using legal profession disciplinary proceeding rules 2017. So please don't use 1994. That one is a dinosaur era already. Now we are new era already. Okay. Rule 6. No complaint relating to the alleged misconduct of any advocate and solicitor concerned, or the legal firm shall be lodged by the complainant after the expiration of 6 years. So it's 6 years. So I think this is the answer. So when they say it's 3 years, then you say it's not incorrect. Pursuant to Rule 6 of the legal profession disciplinary proceeding rules 2017, the limitation should be 6 years. Okay. Can also use section 99 sub 3 capital A. Let me see. 99 sub 3 capital A. Wow. Okay. Thank you. This Z highlight. So our friend Z say, since we can bring in LPA, so LPA section 99 sub 3 capital A actually also mentioned 6 years. Very good. Thank you, Z. Okay. Then we go to next one. B. Whether A may apply for judicial review. Okay. So I think you guys should know what is judicial review, right? So basically it's a review of a governmental order. So let's say DPKL today want to forfeit my land, my property. So then I want to challenge DPKL decision so I can file judicial review. Okay. So judicial review basically is an action. So right now they are asking, since disciplinary committee, which is DC, in the course make a ruling in the course of hearing of the complaint, which means complaint, DC receive, DC make investigation, make a ruling, can A ask for judicial review or not? Okay. So I think this one is slightly complicated actually. I don't know this our Z friend can give us any law or not, but actually I do have a case law. Let me show you. But like I say, this is 4 marks only. So it's like a yes or no answer. So unlike like 5, 6, or 10 marks, you can jump or correct a bit to argue. But this kind of question is they don't want you to argue. They basically have their own answer already. So the case I found is this Ong Keng Yong. Ong Keng Yong. Let me close this one. This one. Closer. Never mind. Okay, so according to this Ong Keng Yong, he basically also want to file a judicial review. But unlike in our facts, basically in this case, DC make a report and affirm DC finding on liability. So like I say, DC is not a boss. DC is just a panel to make investigation. So DC make a report to say there is a liability on this Ong Keng Kyong. But the DB, respondent here is the DB. DB disagree with the punishment recommended against the applicant. Applicant is the Ong Keng Kyong. So basically it's like this. DC make a report to say, yes, Ong Keng Kyong liable. So submit report to DB, the boss. The boss can make decision whether they want to accept or they want to have more harsh punishment or not. So in this case, DB disagree with the recommendation. They say we should have more. They say they want to enhance the punishment here. So DB say they want to enhance the punishment. So because of that, this Ong Keng Kyong go and file judicial review. So whoever familiar with judicial review chapter will know, right? If you still can appeal, you still can make appeal. The law, the court generally don't really accept you go and file what we call judicial review. Let me show you if I have a case law. I think I have. Okay, then my case is this. If there is an alternative remedy, the judicial review will be dismissed. So basically, this is the understanding, which means if you can appeal, why you don't want to go to appeal? Why you want to file judicial review? What if you file judicial review, or at the same time also you file appeal, then isn't later two decisions will conflict? So generally, they will encourage, if you have other choices, please go for other choices first. Then only you come for judicial review. So similarly, the disciplinary board, the boss, actually haven't come to any conclusion yet to say what kind of punishment they want to impose. But then this Ong Keng Kyong already go and file judicial review. So what the court say in this case, I should jump to the conclusion, because I believe not everybody like to read judgment, right? Okay, one thing I think very interesting to highlight, actually, if you flick to 103 EA, 103 EA LPA, can we flick to 103 LPA? Never mind, I think some people maybe don't have. And one student always don't have this book with him one. So let me search for you. Give me a moment. Let me download the LPA. I open wrong shit. Okay, yeah, this is the correct one. So 103 EA 103 see 103. Is it 103 EA? Just now I mentioned. 103 EA, yeah, correct. How come slightly different from my one? Wait, let me see. 103. Or maybe my statute is the updated version. Yeah, different from mine. How come? Oh, I think it's not 103 EA. It's 103E. Sorry. Guys, sorry, is 103E sub 2. So you see, 103E is appeal for a final order or decision of the disciplinary board. So if you look at sub 2, it's deleted, right? Deleted. But one interesting fact I want to highlight is actually last time 103E sub 2 expressly mentioned there shall be no judicial review against any decision or order made by DB, the boss. So which means technically last time you Lansong cannot judicial review. But right now, since they remove already, actually you can judicial review. However, in this case, they still don't allow you to do judicial review. It's because, let me read. Hence, here. Therefore, we should not interfere at this stage until DB has considered the form of punishment to be imposed on the applicant, which is Ong Keng Kiong, under Section 94. Accordingly, this appeal should be dismissed, but without prejudice to such further application as the applicant may desire to make in the light of the proceeding taken and the order to be made by DB. Which means they are not denying your right to file judicial review. They are just saying, since the DB don't even have made the final order, final punishment yet, why you want to file judicial review at this stage? And your judicial review is premature, okay? Because like I say, last time there is an express provision to say you cannot file judicial review. But right now they removed the wording already. So the court recognizing it, the court say, actually you can file judicial review. But then, pursuant to the principle we know, we are reluctant to accept the case where you still can appeal. And some of these not appeal yet. You can appeal. Oh, by the way, I don't know you guys know or not. Lawyer can appeal 3 times. Generally, all the civil case, criminal case, you can only appeal 2 times. Like magistrate, go to high court, high court, go to court appeal, or you from section court, go to high court. High court, you go to high court appeal, then you go to federal court. This is normal one. But then for lawyer, we are super nice one. We can DB make a decision, you appeal to high court 1 time, high court to court appeal 2nd time, further go to federal court 3 times. So a lawyer can actually appeal 3 times for disciplinary action. But I believe nobody want to take that. I rather don't have any action against me. We do have a sections 1. Let me highlight to you. In case this year if they ask, wow, then we all become famous already. 3 times. Let me see 3 times. Okay, I've written here, but I don't know where is the law. But never mind, later we do what? Oh, okay, there's one student asked, DB is a government body. Before we say whether he is a government body or not, I would think he is a statutory body. Why? Because since you ask, then might as well we just go to that chapter. Okay, so for the first chapter, basically, in your LPA, they do mention what is LPQP. So LPQP is a statutory body established under LPA. So LPA say there's a body called LPQP who will have an exam to torture the CLP student. So this is stated in the LPA. Okay, but in other way of not like what I say . Then Malaysia Bar, Section 41 also said there is a statutory body called Malaysia Bar to govern all the lawyers. Okay, then we also have a Bar Council. By the way, I know many people who don't know the difference between Malaysia Bar and Bar Council. So, Malaysia Bar is our all lawyer boss, is Malaysia Bar. But the management control Malaysia Bar is called Bar Council. So, don't ever say I want to sue Bar Council because Bar Council is not a body. Bar Council is a management. Okay. However, I know why people are confused to use Bar Council because Bar Council actually is in UK. The bar they call Bar Council, but in Malaysia we call Malaysia Bar, and the management is Bar Council. Okay, please understand that. And then another one is State Bar which is you are practicing in KL, then it's KL Bar. You practicing in Selangor, it's Selangor Bar Okay, but they call committee I think committee. So to answer these end questions whether DB is a government body or not similarly, DB also established under LPA, so they are statutory body. So statutory body you can consider as a government but actually if you really refer to judicial review they are not only referring to government, they say quasi-government or governmental order also you can file judicial review, which means if your function perform sounds like government, is subject to judicial review also. Not necessarily you must be a government. You perform like a government also, you can file judicial review. You get what I mean? Okay? You don't answer, I will take it as yes, you understand. Okay? So let us come back to these questions. So basically, if you want to against DC in the course of hearing, lagi cannot lah. Why? Because DC is a person who do investigation only. You don't even have a final ruling yet. How can you file judicial review? And apply Ong Keng Kiong the case just now, we will say it's premature because DC not even DP yet. Okay. And also they said, then how about we got the final decision for DC? Also answer the same. It's not. Because in Ong Keng Kiong, even it's DP, it's go to DP already. The court also they say you cannot file judicial review because it's premature. Not to mention DC, because DC is a way premature than DP. You guys understand what I'm saying? Yep. Okay, like the principle I say, no question from chat box. I assume you understand. Okay. I will share this case also. Wait. Ong Keng Kiong. Okay, share already. Okay. Okay, so let us continue. Okay, so we go to next one. Whether A may seek cause from M as he believes the complaint is frivolous. Okay, like I say, same principle. 3 marks should be quite easy. Why? Because it should be yes or no answer. So if I may have all the students who go to legal profession disciplinary rules, I think everybody agree, right? This is legal profession disciplinary rules, right? It's not LPA, it's not something, because right now we are talking about disciplinary action. And I may not happy this person filed a claim against me, and I think it's furious. So I think from the index, actually, we can find the answer already. Let me see. Where is it? I think either they talk about cause or they talk about failures. They will mention the word one. Where is it? Never mind. I look at my own answer. The answer should be. Oh, okay. Sorry. I think I'm wrong. Should be 103 LPA. It's not LPPR. Okay. Sorry. So let us go to LPA. 103 EB. 103 EB. 103 EB. 03. Is it? Let me see again. 103. Yeah, correct. Where the DB determine the application, blah blah blah. This is not important. And further record the opinion that application or complaint were furious of wishes. The advocate and solicitor may, by originating summon OS, to be heard before a judge, ask the court to order the cost of the application complaint shall be paid by the person who make the application or complaint. So the answer should be 103 EB. So you can actually ask for cost. Our A friend can ask for cost pursuant to 103 EB. This one. Okay. Then next one. Okay, again, I would like to share. I noticed actually quite many situations we can find the answer from the statute one. So when you go for the exam, please calm down. Whenever you see those questions like this, like 3 marks, 5 marks, 6 marks, try to find the statute, see whether you can find the answer or not. Honestly, I don't know everything also. I also try to find myself. So of course, the difficulty part is you may feel stressed and also the time constraint. But like I say, calm down and then try to attempt. Okay. Then the standard of proof. So this one is actually based on case law. So I don't know you guys know the case law or not. My own case law is this one. I show you case law. I'm using this one. But the answer when you say beyond reasonable doubt, I think you can get the marks already because it's just 2 marks. But I'm using this case law. Whoever got other case law, you feel free to use as long as it's beyond reasonable doubt. Unless today you tell me you got the case say balance the probability, then I will shake my hand. I will scare, you know. Okay. E. A wish to negotiate a settlement with M if the settlement is reached. Whether the complaint will to automatically drop. A is unsure whether any other person, including the bar counsel, may substitute in place of the complaint to pursue the complaint. So this is like I mentioned earlier. Usually they would like to ask you is, oh, if I drop the complaint, can the bar counsel continue or not? Something like that. This is a question also, please take note, ask a few times already. So the answer should be this one, Rule 8 and Rule 9 of the Legal Profession Disciplinary Proceeding Rules 2017. So let us go to Rule 8, withdrawal of complaint. So the complainant can anytime before final decision to withdraw. This one no issue. Okay, so we answer first part already. Memang when you come to conclusion, come to settlement, you can withdraw. Rule 8 says so. But the next question is whether bar counsel can substitute or step into the shoe or not. The answer is yes. Intervention by bar counsel. So bar counsel, they can still continue the action if they find there is a case. So the answer is Rule 8 and Rule 9. Okay. Simple. Okay. Okay. Like I say, no question. I will take it as a yes. Let us go to another one. B. Oh, okay. So this one basically is a person who was called into the bar and then was found guilty and struck off a road in New Zealand and then want to recommence his practice, and then the wife also keep on nagging. Really, the wife keep on nagging. So he want to remove his name. So please take note, is remove his name, is not to restore his name. He memang cannot tahan his wife already. He want to remove. Why? Let us go to 4A Roman 2. How to apply to his name to be removed. So memang got such application to remove one, which means I don't want to restore at all, not a chance, because I also don't want to become a lawyer already. So the law, let us talk about this question 4A Roman 2 first. The answer should be let us also go to our index, LPA. See, restoration, I think you guys know, right? Restoration is 107. Okay, remove brother and sister, cousin. So one is remove, one is restore. So the answer should be 105. It's not 107. So he want to tell his wife, now I remove already. You don't even think about ask me to restore. I cannot practice as a lawyer already. 105. 105. 05. Yeah. Bear with me. 05. If later he regret want to restore, then take CLP again. I think this is the answer. But you don't need to advise so details. Why? Because it's only 5 marks. It's only 5 marks. So maybe I don't know how he going to restore. Maybe the moral is that the wife don't nagging. Should ask the wife don't nagging, so he shouldn't remove his name. Like say for CLP so hard and now want to remove the name. So the answer is 105, by the way, guys. So he asked about the procedure. So all the procedure is here already. So I don't want to go into details. Basically, you can bring in LPA and the LPA procedure is here. So I don't intend go into details. Then we come to here. The recourses that bar counsel may have against bond. Actually, this question I don't understand what they're asking, because Bond is already struck off in New Zealand. Now, Bond also don't want to recommence his practice. What? Okay. His wife want his to recommence, you know. It's not he want to start to restore or want to practice again, you know. So they say Park Hauser, what Park Hauser can do? I don't know what Park Hauser can do unless the wife is a Park Hauser, right? Okay, I will put section 88A. Actually, yeah, I will put section 88 but not 88A. Chun, thank you, Chun. I don't know whether I pronounced your name correctly or not. So basically for question 4A Roman 1, they say what recourse Park Hauser have can do something on this bond. So our friends say is section 88 capital A. So capital A is suspension. However, remember why I say it's not suspension is because suspension means the lawyer is still practicing like Reno. Reno is practicing. So Park Hauser right now want to suspend. As Reno cannot become a lawyer for a moment, suspend. But then because he totally is not a lawyer at all anymore, so I don't think we use this one. I think the Park Hauser maybe can use this one. Guilty advocate solicitor. Why? Because Bond was convicted in New Zealand, so since he's a guilty lawyer, so when he want to start practice again, Park Hauser have the power maybe to review whether want to approve or disapprove. My opinion is that since it's just 5 marks only, I think it's section 88 . Okay, we have a friend Dennis Wong mentions section 94. 94 sub 4. Let us see 94 sub 4. 94 sub 4. Where an advocate or solicitor has been found guilty of court of law offense, blah blah blah. Can also. Very good. Dennis, very good. Yeah. Okay, another one. My suggestion, Reno, disclaimer, Reno put is section 88. Our Dennis Wong put is section 94 sub 4. So if wrong already, you guys go and text him. And then another student, Senda. What was the standard of proof for D? Question 3D. Okay, the standard of proof is beyond reasonable doubt. Beyond reasonable doubt. Actually, okay, Dennis Wong asked another question. Actually, section 88 capital A and section 94 sub 4 are very similar. How to differentiate? My personal view 94 sub 4 is for those lawyers are still practicing. That's why 94, the title is power of disciplinary board, which means they haven't struck out yet. You are still practicing. So I want to check your conduct. I want to review your performance. But then section 88, on the other hand, if I'm not mistaken, my feeling, I stand to be corrected by Dr. Chi. Park Hauser may have reasonable cause to believe the advocate and solicitor, blah, 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 has been guilty, dishonor in connection, blah, blah, blah. Yeah. So I think it's like after struck out, then where the name is removed from the role and suspended for practice. So which means this one is applied after he already removed, already suspend, and now he want to come back to practice. So section 88 apply. What was the answer for question 3C? 3C. 103 EB. 103 EB. 103 EB is for question 3C. Okay. Okay. So I think this one is quite easy, right? This one is section 88 and 94 sub 4, and then this one is 103. 105. This one is 105. Okay, everybody, okay? Shall we proceed? Welcome, Dennis Go. This Dennis is very handsome guy, by the way. Okay, so B. A graduated with Bachelor of Law from National University of Malaysia in 2000. He then entered service with Royal Malaysia Police and has been a prosecuting officer in lower court and subsequently served in the legal unit of many branches of the force. He is urged to commence pupillage and have approached his old friend George, who was formerly a magistrate at Telong Tato for 5 years and practiced in Klang, Selangor 6 years, and now practicing in Labuan for past 2 years to be his pupil master. Okay, can I before that test you guys in order to be a pupil master, how many years in practice must have? 7 years. Yes, very good. 7 years. So which means our Dr. Chi. Why I see so many people answer? Why other question no people answer one? So our Dr. Chi master, Christine, right? who practicing more than 7 years already, even more senior than me. So it's like super senior. So yeah, 7 years. So on the facts, you see here, practicing 5 years, magistrate 5 years, practicing 6 years, but then in Labuan 2 years, right? So of course, this is the tricky part, whether you consider Labuan, include Labuan or not. Because if include Labuan, they got 6 years plus 2 years, so total 8 years. So let us look at the questions. Whether there's any provision which allows shortening the privilege. Okay, come, whoever who answers 7 years, come tell me any provision to say we can shorten the privilege. Come. Which sections? Anyone know? I see an answer already. Section 13. Yes. Can you give me a subsection? Which subsection say? Sub 3. Wow. See, all very smart already. Yes. So this answer should be section 13, sub 3, sub A. So basically, you can apply and justify, you can shortening the pupillage. All this actually usually apply to those we call judicial legal service, judicial and legal services. Again, I stand to be corrected. My understanding is that magistrate, sections court, DPP, they all are under judicial and legal services. My understanding is that. So that's why you can see cases, or you study criminal, the judge can become magistrate, then suddenly transfer to become DPP. So all these people, because they are under judicial and legal services, they are not lawyer. They can practice as a DPP without become a lawyer. My understanding is that. So that's why when they come out, they want to become a lawyer. Takkan they practice like so many years already as a prosecution. Now you ask them to become a pupil for 9 months. So that's why this provision actually is designed for them. So you are PPP, PT last time, actually you can apply for shortening your privilege because you have sufficient what we call experience. So you can apply there. Okay. This one I think since so many people get answer already, then we jump to the next one. Okay. Whoever don't know, then ask those people answer like Suba, Chun, whoever answer correctly. Okay. How about section 13 sub 4? Let me read. Can also, actually, section 13 sub 4 also can. Because why? If you join judicial and legal service at least 1 year, here you see, they joined so long ago, actually he can apply also. I think section 13 sub 4 is even better. But let me read again. Oh, wait. Oh, yeah, can. Because he is a prosecuting officer. Yeah, that can. Section 13 sub 4 can. Okay. So thanks for this, Zach. Section 13 sub 4. So next one. Whether George has the requisite qualification to be a pupil master. Like I said, just now we all mentioned, if you want to become a pupil master, you must at least have the 7 years. So pursuant to section 13 sub 1, 13 sub 1 only mentioned a pupil shall serve his period of privilege with an advocate solicitor who is and has been in active practice in Malaysia for a total period of not less than 7 years. So not less than 7 years in active practice in Malaysia. So this is all the wording he's using. So for me, Labuan is part of the Malaysia, so it shouldn't be a problem. I will argue in that way. Let me see, section 13. Advocate solicitor has been in active practice in Malaysia for total not less than 7 years. So my personal opinion is that since he's practiced in Clan 6 years and then in Labuan 2 years, my personal opinion, I think it should be okay since they say in Malaysia, the wording is in Malaysia. They are not mentioning like in West Malaysia or East Malaysia. So I think it's fine. But of course, I stand to be corrected. Anyone got any different opinion? Okay. I think I can further highlight section 2 also. Because section 2 also say this provision actually apply to Sabah Sarawak also. This act shall apply throughout Malaysia, entire Malaysia, but shall only make applicable to Sabah and Sarawak with such a notification as the Yang Dipertuan Agong make order. So unless you guys or Dr. Chi or Mr. Gan or whoever can tell me any law passed in Sabah and Sarawak to say LPA, they don't apply or they don't accept. Otherwise, we shall take it as yes, Labuan also consider part of the practicing is included. So more than 7 years can become a pupil master. Okay. So I think we settle our ethic and advocacy already. So do you guys have any question? Any question? Any questions? I think land I checked Dr. Chi answer all is correct already. So he super pro already. So we don't need to go to land law. So whoever haven't attend the land class, maybe can go and watch the YouTube video in Dr. Chi YouTube channel. Okay. So if no question, then we can jump to our section question 9. Okay. So question 9, basically they mention a lot of things, but actually it doesn't matter. Why? Because you see, they talk a lot of story, but then at the end they just ask you the type of letter of representation that he may apply. So basically they are asking you what kind of representation I can apply. So by the way, many of you maybe don't know what is letter of representation. Actually, letter of representation include grant of probate and also grant of letters of representation. Letters of administration, LA . I will call it LA. LA means when there is no will. Probate means there is a will. So letter of representation include these two, LA and probate. Okay. So when they ask you what type of letter of representation, basically then you just explain they are two type. But then let me show you. Just give me yeah, we see our friend Mr. Gan left already. Sad. Okay, let me off all these things. Too many. This one I think can. Wait. I'm waiting. Okay, yeah. So the type, although just now I mentioned we only have two type, which is probate and LA. But then in certain situations, where you have a will, but then you don't have the proving executor. Why? Let's say today Reno prepare a will, so Reno appoint Dr. Chi become my executor. So when Reno pass away, Dr. Chi say, I don't want to become an executor. I don't want to act for Reno because Reno is very bad guy. So in that case, when my executor not willing to act, or incapacity due to insanity or old age, maybe Dr. Chi is older than me, so he cannot conduct this thing. In that case, although you have will, but they will call it LA with will annex. So like the title suggests, LA, but then we have will, LA with will annex. So this is second type. And then the last type is LAD bonish known. So this is where granted where probate or LA have been extracted but not fully administrated. So what does it mean? It means that we apply LA or probate, never mind, we apply either one. So we apply either one already, but then we never continue to do the necessary step. So in that case, you can apply to the court because the court is not going to issue a new LA, new probate to you. So the court will give this called LAD bonish known. So this is the first part for the questions already. We have 4 types. So let me repeat. Probate means there is a will. LA means there is no will. But if with the will, but then the executor doesn't want to add, then we call LA with will annex. Then fourth one, LAD bonish known means when the LA or probate has been granted, but then they never take the necessary step, the subsequent step. So you can ask the court to grant another one called LAD bonish known. That's it. So this is of our 10 marks. I think it should be okay 4 type. Each of them you talk 2 marks, 2 marks, 2 marks. Then you can get 10 marks already, I think it's quite okay. Then shit. Oh no. Meeting room. How come Mr. Gam come back again? Okay. Last one. What is caveat? So caveat means this caveat is not the same as the what we call land caveat, but they are quite similar. So basically, the effect of caveat you enter on the land is to prohibit the subsequent dealing. So for example, today I want to sell my land to Dr. Chi. So, but I worry Dr. Chi may go and sell to third party, I wouldn't know, so I enter a caveat so that Dr. Chi cannot deal with his land with other people. So this is called prohibit subsequent dealing or prohibit dealing caveat. So the caveat on probate means when I want to file an application to apply probate or apply LA, let's say I still owing somebody money. So this person worry my executor or my administrator may or may not pay back the money, right? So what they can do is they will enter a caveat. So the effect of the caveat is to blocking so that my executor or my administrator cannot get the probate or LA because they're blocking already. So the caveat is like a lock, they're blocking it. So it becomes you cannot get the probate or LA unless you apply removal or you settle with the person. So the removal, I don't know you guys familiar or not, but basically it's a loose of court. I think you can just memorizing it. So basically you serve a notice, you ask them to show cross, which means let's say today I am the executor or administrator. So Dr. Chi enter a caveat on my probate or my estate. Then I can actually serve a notice to Dr. Chi, ask Dr. Chi show clause why you want to enter, on what grounds you enter. So if Dr. Chi has not entered appearance, then understandable the court will remove it within the prescribed time. But if Dr. Chi enter, then Dr. Chi need to show why he entered, why he caveat should be remain. It actually kind of similar to the land, but I think this is more simple compared to land. Because land, I think Dr. Chi mentioned we need to use 326, 327, 3-stage test. That one is more complicated, okay? But I don't want to go into details since Dr. Chi has covered already. Then, when may the caveat be entered? Actually, anytime before the grant, which means if the court already make the grant or make the LA, then only you enter. The time is too late already. So you must enter before the court make the order. What is the effect? So the effect, like I mentioned just now, blocking the people to get the probate or LA. Okay. So when does the caveat cease to effect? Is where you apply for removal. And then what is citation? Okay. Citation, basically, we have three types. So number one, refuse to or accept the grant. So basically, citation, I think you can imagine like, I cite you, come out, please come to court, we discuss. This is citation. So let's say today Dr. Chi is executor, but then he feel like want to add, don't want to add, never say one or don't want, but it's like acting lah. Then I'm not happy I'm the beneficiary so I cite I use citation under order 71 rule 42 sub 1. I say, Dr. Chi, please come to court, tell the court whether you want or don't want. So this is citation number one. Number two, to take out the grant. So let's say this time Dr. Chi take out the grant already. So he become the executor already, but he don't want to continue. Yeah, here say a beneficiary may issue a citation on the executor who in the middle with the testator estate. So he take out the grant, but then in the midst of doing something, but then keep on delaying. I'm not happy, So I can also take this citation to ask him, hey, Winding where I am, please do this thing. This is your duty. This is your legal duty. So I can give a time frame. Ask the court impose a time frame. And last one, to propound a view, to prove a view. So let's say Dr. Chi say, I'm the executor of so and so. So I don't trust him. I say, please prove. So this is the citation I can do. So I say, please show us the will. I want to see whether this is the deceased signatory or not. I want to see whether this is what he written or not. So this is all three types of citation we have. So yeah, actually citation and caveat they like to ask in this form. Just ask you what is that. So basically, I think you guys can do a sample answer for yourself, the nice answer, then you just memorizing it, then reproduce in your exam. I think this is good enough already. Okay. I think professional practice is not that difficult, right? So you guys got any questions? Any question? If no question, then I think we will stop here. It's early than what I thought. 1 hour and a half only. So this one, unlike evidence, because evidence, a lot of people got a lot of questions. So for PP, nobody got questions. So shall we stop here, Dr. Chi?
Yeah, I think good enough. Good enough. Thank you so much for your time, Mr. Reno. Thank you.
No problem, no problem. Thank you
Later
for
you send me the recording as well.
No problem. So
thank you.
Can you teach me again where to stop?
You just press the record button.
Record button. Okay. Where is it?